Hey, Brian Parker here, attorney Brian Parker, bringing you more of the good stuff. This is a good case that allows me to also intro or announce to you that we have just signed up with it's actually a nonprofit service that competes with Westlaw and LexisNexis, and has accumulated millions of opinions and cases from state and federal district court. So everything from the very lower court to the Supreme Court, we have now attempting to put in millions of these cases into Parker GPT. So if you're a current member, you will now get even more value. You know, a lot of these chat boxes, we have Parker GPT, which is the AI. A lot of these chat boxes are great, but as far as law goes, they keep making up cases. They're called hallucinations. I don't want that for my members. So I went out and found a service that will put millions of cases, the right cases with the right names and not made up, into Parker GPT. It's unlike anything else available on, if you will, the market. Attorneys, law firms, big and small, use LexisNexis and Westlaw, and they charge quite a price. We're not going to charge you. I'm going to put it right on kildette.com. I'm going to embed it in Parker GPT, so you'll have it as part of your current membership price. So with that said, as I said, the new service, the new national database, will have state and federal court opinions. This case today is about a state court case that went to federal court. And a lot of my lawsuits, whether they're counterclaims or third-party claims, emanate from state claims. I used to sue a lot of federal cases, hundreds, thousands probably, yeah, at least, all over the place, right? So, and they would, it rarely was it because, other than FCRA, rarely because I just got mad at somebody or a client got mad. It largely came out of a bad lawsuit that was filed unsupported against a client, and I either sued under individual action, or a lot of times I did a lot of class actions. This gray hair came from many places. So this is a similar case. This is involving NCSLT, National Collegiate Student Loan Trust. And they have filed about 800,000 of these lawsuits for Bank of America, Chase, quick and easy student loans from 2003 to, I think, 2008. So they now pick up these originally credited loans and they file almost 1 million of these lawsuits on shaky grounds, unsupported documentation. I've sued them in class actions for the very thing I'm showing you today. And we'll be breaking a case down that's called Brown versus Trans World Systems, number 22-35244, 9th Circuit, 2023. And the issue is, when does a debt collector keep violating the law such that the 1-year statute of limitations of the FDCPA continues? So a lot of times, like I said, when I'm suing on a lawsuit, I'm saying, hey, May 23rd, 2023, they filed this BS lawsuit. I can sue up to May 22nd, 2024 on that violation of filing that lawsuit based upon false or unsupported documentation. That would be 1692, one of the things, 1692E5. Knew or should have known you shouldn't have filed that lawsuit. So when are you stopped from filing a lawsuit under the SOL? When you've been sued by a shaky lawsuit. Most of my clients, most of my members are suffering or at the hands of lawsuits that are complete BS, and they got to do all the work to show the court. So in this case, from 2003 and 2006, O'Shore Brown, Mr. Brown, took out 10 student loans. Back then they were very prevalent. Everybody was giving them away. And there was a securitization mechanism set up. As soon as the creditor got the debt signed for, the creditor, let's say it's Bank of America, quickly put it into a bunch of trust and securitized it. And eventually it ends up in the hands of the National Collegiate Student Loan Trust, NCSLT. And in this case, there were 10 of them. So NCSLT is an entity that doesn't exist in theory. There's no brick and mortar, as they used to say. It's just a computer blip. Okay, let's call it that. But the actions to be taken are done by a collection agency. So when they want to sue, they sue with a collection agency called Trans World Systems. I've gone after them a lot. I used to know them quite well. I think they're out of Georgia. So they are operating with a U.S. Bank. U.S. Bank is the trustee of all these, tons of these trusts. Most of them were sued in this class action by Mr. Brown. After they started coming after him, Mr. Brown filed for Chapter 13 bankruptcy, made all his payments for 36 months, and he received a discharge of the order. Side note, these, if they're considered education loans, it's very hard to get an education loan discharged in bankruptcy. But I always argued that these aren't bankruptcy immune. They're not really educational loans, which are tough to kill in bankruptcy. They're just personal loans, and they're not, I don't consider them education loans. And more bankruptcy attorneys agree with me. And in this case, the bankruptcy court discharged all the debts. That's not going to stop a debt collector. So they went after him on all 10 debts anyway. And they served, this is weird, but I totally get this, having dealt with this company and the law firms or debt buyers in general. They served Mr. Brown with the lawsuits before they actually filed the lawsuits. The very first case I did with NCSLT was like 5 cases. Boom, all just came in, and they're all the same dreck, in my opinion. And there's no care there. And here they served him on him before they even filed it with the lawsuit, with the court. And they served it with a affidavit. As you know, we've talked in the past, or just about all the time, debt buyers, and that's what NCSLT is, it's a debt buyer. They don't have the ownership. So they prop up the case with an affidavit saying, yep, we own it because we say so. So in this case, they had Jennifer Odette had a affidavit saying, yep, NCSLT owns these debts. And Mr. Brown's attorney got that affidavit thrown out because it did not prove NCSLT owned the debt. So what NCSLT did and what they've done, now I used to sue, I've deposed this guy probably 4 or 5 times, I think. They got a Bradley Luke to come in with a new affidavit and say, yep, we own it because we say we do. And they came up with a whole new theory. So did that mean the theory of Miss Odette was not true? But they came up with a new theory of ownership of the 10 debts. And the state court said, no, not so fast, Charlie. This isn't passing the smell test. It's going to be thrown out. It was thrown out under hearsay reasons. Remember, everything is hearsay unless you've got an exception. They could not get an exception. 8036 exception is tough to get through, especially out in the 9th Circuit, and we'll get to that. But here are key dates for you. February 16, 2019, Brown is served with the lawsuit, but it hadn't been filed. April 5, 2019, the complaints are actually filed. I can't believe they run a railroad like this. Anyway, so October 17th, the new Luke affidavit, Bradley Luke, who I've deposed and run through the ringer a long time, he filed claiming ownership of the debts. Then what Mr. Brown did is of what I've done all the time with NCSLT. He filed a FDCPA lawsuit saying NCSLT is not only violating against him, but in a class action against every NCSLT iteration. So you'll see NCSLT 2007, NCSLT 2006-3. It's just tons of these NCSLT entities that don't really exist, but they operate through Transworld Systems. So he filed, as I have always done, for filing a false lawsuit. And the legal issues that came before the federal district court were 2 things, 2 claims. The defendants in this case in the class action are NCSLT. So they violated his bankruptcy discharge because he had got a bankruptcy court order saying your debts are gone. Number 2, they filed a knowingly meritless case. That's almost word for word how I put that. They filed that lawsuit because they knew even though they knew they couldn't prove the debt. And that's, look up 1692, well, many 1692Es. Look up a lot of 1692Es, specifically 5 and 10. So the district court, however, saw it NCSLT's way and said, sorry, if you have a bankruptcy claim as to claim 1, you have to go back to the bankruptcy court and say, hey, they're violating the bankruptcy order, and you can't bring it in a separate court under the FDC. You have to look for a contempt order against NCSLT in the bankruptcy court, and he was just in, if you will, regular federal court. But the bigger fight was the statute of limitations. The FDCPA gives you just 1 year. I don't know if you're aware of that. It only gives you 1 year. So when there's a violation, the clock is ticking. You got 365, baby. And so a lot of times you've been sued and that case goes on. And now you go, hey, I'm mad at these guys. I'm gonna go file. It's too late, the year has passed. So keep an eye on that. But there's a way around that. This is what this case stands for and how it can help you. Here's what the statute of limitations under the FDCPA looks like, Shazam. And an action to enforce any liability created by this subchapter may be brought in any appropriate United States District Court without regard to the amount in controversy, meaning it's a federal question. You don't have to prove there's a certain amount. Or in any other court of competent jurisdiction. So you can file in state court a federal FDCPA claim, and that's what was done in this case, but they removed it. The defendants removed it to federal court where they felt safer, and that happens a lot. But this all must be done within, and here's the quote, 1 year from the date on which the violation occurs. So NCSLC is going to say, you took too long. Even if we violated, you were more than a year later. So let's take a look at that. February 16th, Brown served. April 5th, 2019, complaints actually filed. October 7th, 2019, new affidavit by Bradley Luke. And then April 6, 2020, Brown filed his lawsuit. So if you notice, April 6, 2020 is still 1 day older than April 5th, 2019. But there were holidays, or I think something fell on a Sunday. So if something falls on a Sunday, you get an extra day. So Mr. Brown said, hey man, I got this in on time. What's the problem? The federal district court said, nope, your time ran out 1 year after you were served. So the first contact he had with the case was when he was served in February 2019, and the court said, too late, April 2020 is way too late. So what did Mr. Brown do? Mr. Brown went to Appeal Town, and he filed with the Ninth Circuit Court of Appeals. Let's quickly look at that. Here's a picture of the state with all these Circuit Court of Appeals. And if you can see the orange on your left there, that whole swath of this quite a large part of the United States is the Ninth Circuit Court of Appeals. So if they rule on something, you better believe people are listening. In fact, a lot of cases go to the Supreme Court from this district. In fact, in 2024-25, 5 cases came from the Ninth Circuit alone, which is the second most of all the circuits sending cases to the Supreme Court. So the Ninth Circuit took a look at this case, and it held that certain litigation acts, including service and filing, can constitute distinct violations of the FDCPA. So even though he was served with a lawsuit and not filed against, when they filed, that represented an independent action. So the statute of limitations started when he was served, he's got a year, but then when they went ahead and filed it, that started the statute of limitations again. So now you got a year. Some people say, well, what's the big deal filing? You don't even, sometimes, and it's true. I mean, I talk about garbage time. Generally, lawsuits are filed against you, but you don't hear about them until they're served. And sometimes that's months. And I talk about keep an eye on the court record, and that's garbage time. So you should do a bunch of stuff against the guy that you know is eventually going to serve you. So here, the court said, sorry, distinction is to be made between filing and serving. Because even if it's just filing where you don't know about it, that can affect your credit report, your financial reputation's impacted, because people pick up what is filed with the court. So that is an independent violation. But the court said, as courts always do, there's a 2-part test to figure out if something is independent. So what I mean by that is a lawsuit's filed against you. Litigation occurs. So from when the lawsuit is served or filed, to the end of the case, there's litigation. Most of that stuff is not an independent action. It's part of the lawsuit. You can't say, yeah, 3 months later they served request to admit, so the statute of limitations starts all over again, unless those are complete BS. Where there are cases, I've had them, where they're such badly done and based on falsehood so bad that courts do go, you know what, that's a violation. That's not part of the original action. It's an independent action. So in determining whether an act is independent, the court says the debt collector's last opportunity to comply with the statute. So when it does something and breaks or violates the law, that's considered in courts as the last opportunity to do the right thing, to comply with the statute, and they go south instead. And two, whether the date of the violation is easily ascertainable. And we're going to find out why that was the case here. The panel, the Court of Appeals, concluded that Brown sufficiently alleged post-filing FDCPA violations. So again, if you're sued, that violation starts there. That 1 year statute of limitation starts there. There's a bunch of filings by both you and them. If it's part of the original filing, it's the statute of limitation isn't stopped, okay? Or doesn't start again. So the key holding here, there are three key holdings. Number one, each separate FDCPA violation gets its own 1 year statute of limitation. That's clear. Number two, certain litigation acts can be independent FDCPA violations. So that means, as I said before, generally litigation doesn't start a statute of limitations. You can have times where the debt collector, maybe the attorney, does something so egregious or so in violation of the law that that's an independent action and a new statute starts. So if you miss the first statute that begins in the filing, you have a new statute. But remember this, if you're able to get into that new window, that new statute of limitation, that 1 year starts again, you cannot say anything about the old statute of limitation that started and ends at a certain time if you file on the second violation, the independent violation, and the 1 year on the original violation has expired. You can only file it on the actual new violation that starts the statute of limitations. Otherwise, and this goes both ways, otherwise debtors would be going, yeah, back in 2019, I know it's 225 now, but I got in the and they were bad guys. You can't do that. It has to go both ways. So the court created that two-part test. Number one, was the debt collector's last opportunity to comply with the FDCPA? When was it? Is the violation date easily ascertainable? Is there a specific time that we can show that that statute started again? Holding number three was when service happens before filing, like here, the filing itself can be separate. A different new violation with its own statute of limitations because of the financial reputation or credit reports and costs of defense that come out of the new filing. So this matters to you for the following reasons. When the statute of limitations starts on a debt collector's violation of the law is very important to your ability to file a lawsuit against the debt collector, the creditor, or even the attorneys. For debt collectors, they can't just file a lawsuit and then commit unlimited FDCPA violations during the litigation. So back to what I was talking about. They filed this lawsuit and you've got a year to sue them for it. They can't just say, well, sorry, it's a 1 year statute of limitations. Today is the 367th day. In all that time, I've only been filing bad things against you, but you forgot to sue me. No. If they do stuff that's egregious or in violation, the FDCPA statute of limitations starts forward again, but you can't sue backward if the statute of limitations on the original filing has passed. So you might have more time to sue than you think. It is quite possible too that you can sue, as I've always done, especially against NCSLT, that they violated their law by bringing a BS case, and they, in this case, filed a BS affidavit. You quite possibly end up just suing them for the affidavit. You get to sue them, but And you can talk about the case, but you can't sue on that state case against you as a violation. So it's a big win for consumers. You just got to be careful with it. It extends your ability to sue the bad guys. Now I want to talk about the Luke affidavit. So there was the Odette affidavit filed with the original state claim by NCSLT. It said, we own the debt, here's the reason. The court and Mr. Brown got it knocked out. So they filed a new one from this Bradley Luke, who, as I said, I've deposed him many times. How can I say? He's a slippery guy. He does what he does. And he files this new affidavit in the same case, but with new reasons why NCSLT owns the debt. But that was a violation. You can't make stuff up like that. And the court said, yep, that's hearsay, you can't bring that in. That is a new violation, independent. The first affidavit was by somebody else. This is a new independent, and it's independent, the court said, because it brought up allegations and reasons for ownership not mentioned in the original case. Thus, the independence, thus the first year starts again. So I'll read to you what the court held. I'll put it up. The court held in this case that Brown has alleged a one post-filing FDCPA violation. So we'd love to bring in the bad stuff they did by filing 10 cases when they had no right to, especially when it was discharged, yada, yada. But we can only here file on the post-filing Bradley Luke affidavit. That's not going to be the case all the time. You've got ample opportunity to get in with the statute of limitations and include both the bad filing. Probably every lawsuit I filed against NCSLT stemmed from filing a lawsuit against my clients with bad assignments. In this case, the person went over the year statute of limitation, but got in because of the Bradley Luke false affidavit, if you will. So in this case, we conclude that Brown had alleged one post-filing FDCPA violation, the filing of the Luke affidavit. By filing a new affidavit that attempted to show that the trust owned the debts, defendants did more than reaffirm. So if they're just filing something that reaffirms what they already did and the year passes, you're out of luck. But if you make up new stuff, as in the case here, or if you add new stuff that isn't part of the original filing, it's independent and it's not reaffirming something, because it's new stuff, so it can't reaffirm. If it's new, it can't reaffirm old stuff. So the original affidavit was from Odette, but the new Luke affidavit presented a new basis not contained in the complaint to show that the trust owned the debts. When defendants ceased to rely on the Odette affidavit and moved forward with the Luke affidavit, this discrete event created a last opportunity to do the right thing, but the court said last opportunity to comply. So the last opportunity to comply, again, is actually another word for violations. So the practical takeaways here are: don't assume the statute of limitation is run just because the lawsuit is old. Look for new filings, affidavits, or litigation misconduct. Again, there may be no new filings, or the debt collector files something that is so wrong. Again, there was one case I read where they filed requests to omits that were total BS. They were just unfounded and wrong and just really propped up something bad already said. So that alone was a violation against the debt collector attorney. The document everything. I've talked about this in the past. Make your own court docket. So if you suspect you're being sued or you have been sued, the court creates a court docket you can go online and check out. Nothing prevents you from making your own court docket of when you did stuff and how you did so. If you sent something certified return receipt requested, write that down right when it was signed for, right when you received it. Make your own court docket and figure out how you can sue these bad guys when nobody else is keeping track of this. So Brown versus Transworld System shows that the FDCPA statute of limitation isn't as simple as a 1 year from the lawsuit. That's what debt collectors want you to believe. You should take that from this video. Sorry, we filed the lawsuit here, you missed it by 3 days. Each violation gets its own clock, and debt collectors can create new violations during the ongoing violation in litigation. In short, some litigation acts may constitute independent FDCPA violations. That's what this case stands for. Otherwise, debt collectors could just commit unlimited debt violations after commencing an improper debt collection lawsuit and say, sorry, the statute ran. So if it's bad, it's probably independent and it isn't complying with the law. I hope that's a good takeaway for you. Again, great news. If you remember, you're about to get millions of cases embedded in Parker GPT. Parker GPT, I use it in my law practice, has already blown me and others away. Because, frankly, if you're using ChatGPT, it's great for some things, but it's very general. So if you ask it one thing, you'll get 50 responses, right? And it makes up cases that don't exist. They're called hallucinations. I'm gonna say to you, 9 out of 10 inquiries I make come back. So I've gotta figure out everything. And I used to use ChatGPT as a skeleton. Then I'd add the muscles, add the facts, just to get me started, like twisting most of the cap off, and then I can just twist it myself. So it's useless for lawyers. I use Parker GPT because it's just focused on debt defense. Yes, I am tooting my own horn, but it's good. I use it. You should use it. Now we're trying to eliminate the hallucinations that none of these big billion-dollar companies are doing by putting millions of case law, the actual real non-hallucinations. In fact, the data service that we're contracting with has a non-hallucination policy. So I'm charging you, I think we charge $149 a month. I'm not increasing the price. I'm increasing my costs, but I'm not going to increase the price when this is embedded. It hopefully will be done by the end of this month, I hope. Developers, you know. So go to killdebt.com. You've got 1,200 documents at least, 435 videos, instructions, tutorials, free stuff, and now you're going to be having millions of database. By the way, again, this service we're using competes with Westlaw and LexisNexis. I'm going to put their icon right on my website, and you can use it as a member for free. That's what I'm doing for you. Thank you. You do more for me than you realize. I enjoy this. I enjoy the comments. If you want to comment on this video, I'd love to hear about it. Thank you. Thank you very much. Brian Parker out.